In late 2000, the 5 law lords examined the details of Baker's case and whether the DNA evidence could have been used. They came down heavily on one side.
The House of Lords ruled that in fact the judge's ruling was incorrect and that the evidence, being compelling evidence, should have gone before the jury.
And the senior law lord, Lord Steyne, went further. He ruled the public had the right to go about their lives safely, that the decision to exclude the evidence produced a result that flew in the face of common sense.
They've stated that there was a balancing act that had to be made. Protection of the public, allowing members of the public to go about their daily lives without fear of harm coming to them. Also, of course, the protection of the privacy of a defendant. And to not take those matters into the equation meant that a common sense approach couldn't be achieved, as we saw in the case of Wendell Baker.
This was all about Wendell Baker's case, but it made little difference to Wendell Baker's life. He'd been acquitted, and as the law stood in 2000, he couldn't be tried for the same crime twice. To this day, Baker remains a free man. But we hope to change that. For 800 years, British law said you could only be tried once for a crime. If you were found not guilty, you stayed not guilty, no matter what evidence came to light. But that all changed in 2005. Prompted by the Stephen Lawrence case, the outrage and concern caused by the acquittal of 3 of the young men widely believed to have murdered the London teenager, the Double Jeopardy rule was swept away. For the first time in Britain, if there is new and compelling evidence, it is now possible to be tried twice for the same crime. We believe that in the interests of public safety, Wendell Baker should be back in front of a jury. To bring about a Double Jeopardy retrial, we had to find new and compelling evidence that hadn't been shown to a court before. We believe that the DNA evidence ruled inadmissible at Baker's first trial fits the bill. We've looked at the Criminal Justice Act and what the guidelines define as new. We also showed the papers from this case to Britain's leading authority on the Double Jeopardy rule.
My view is that the DNA evidence on which the prosecution relied at the original trial is now admissible as a matter of law. It seems to me it does satisfy the criteria for being new evidence. New evidence can be evidence which was available at the time but which was not used. I think it is also compelling evidence. I think it would be in the interests of justice to have a retrial in this case.
So at last, the DNA evidence rejected by the judge in 1999, we believe can now be used in court. But despite the strong evidence for a Double Jeopardy retrial, it could still be a struggle to get the case to court. There has only been 2 cases tried in the 4 years since the new rules were introduced. I'd like to talk to your detectives about any cases. We spoke to most of the police forces across England, and it's clear that priorities lie elsewhere. Some forces said the level of current crime prevented them looking at Double Jeopardy cases. Others admitted they should, but unsolved cold cases were seen as more of a priority by the government. But Double Jeopardy cases should be a priority. Those who knew Hazel say a re-examination of this case is what she always wanted. The information we have discovered during our investigation will be made available to the police and to prosecutors. In the last week, the Metropolitan Police have told us with deep regret they have lost the case file. However, they confirm the DNA evidence still exists. We hope this latest mistake will not prevent Hazel's family receiving justice under the Double Jeopardy rule. We wanted to find Wendell Baker and ask him to comment on his crime and answer the calls for a retrial. Finally, we found Wendell Baker. He's living here in a leafy part of East London. and we want to know what he thinks about our findings, that there is evidence to start a new trial for the attack on Hazel Backwell. We had a long wait for Baker until we were tipped off he was leaving his house.
You're the donkey farmer. Yeah.
Dave, come in. He's got a stick and a dog.
Okay.
He's got a stick and a dog, all right? Shall we go?
Yeah.
Fine. Wendell Baker, my name's Richard Bilton and I work for the BBC. I've come to talk to you about Hazel Backwell. We think we've found new evidence which means that you should stand trial again. We think that justice wasn't served, Mr. Baker, with the Hazel Backwell case. What do you think?
Go suck your mum, you cock.
What it means now is that if we find new evidence and we've found new DNA evidence, then you can stand trial again. You can appear in the dock again. What do you think, Mr. Baker?
Fuck off! Get out my face! Fuck off!
Mr. Baker, what do you think that we should stand...
Please, just go away.
Come again, I'll break your neck.
Go away.
Mr. Baker, we think that there is evidence that you should face trial again.
Go away. Please go away.
What do you think about Hazel Backwell? She never got justice, Mr. Baker. She never got justice. She died wanting to know what the truth is, and the truth is the DNA evidence shows you were there, Mr. Baker. Mr. Baker, double jeopardy means that you will face the evidence again, because the truth is justice wasn't served, was it? So you saw what happened there. Wendell Baker was not pleased to see it. But the fact is, the evidence shows that Wendell Baker attacked Hazel Backwell and justice was never served. We believe he should stand trial again under the double jeopardy rule, and perhaps now the police should re-examine his case.